Hello, I'm Sacha Garben and I'm the Permanent Professor of EU Law at the College of Europe in Bruges. Well, I think that one of the main challenges of the online platform economy or the digital economy in respect of social issues is that of labour and the role of the labour status, the question of the labour status of the workers in the online platform economy, such as the drivers for Uber or the Deliveroo food couriers. And in this regard, we have seen quite some uncertainty on the national level whether or not the people who are working in this area are considered workers or employees, or whether they are, on the other hand, considered independent contractors. And this is incredibly important because a lot of protection, social protection, labour protection, employment protection, occupational health and safety protection flows from this. If you are an employee or worker under national law, you will generally have much more rights and protections. And so judges, but also policymakers, have been struggling with the question whether or not these people qualify as independent contractors or employees because of some of the non-traditional traits of the working arrangement within which they work. I think that the European Commission is already taking some very important steps in this context, also on the back of the European Court of Justice's judgment in the Uber case, to perhaps stimulate a default assumption that the people working in the online platform economy are indeed workers, employees, with the accompanying rights and protections. Unless there really are strong arguments against this. And the Commission is doing this through the proposal for a directive on transparent and predictable working conditions, which may very well be adopted soon, in which it is made clear that workers on online platforms can indeed be considered to fall within the definition of worker as defined by the Court of Justice, and for the purposes of the rights laid down in that directive, but then all EU labour law directives. Now that leaves the question of the applicability of national standards unaddressed, but seeing that we can see an influence of European law, European labour law, on how national labour law is then also applied and interpreted by national judges, it might be that this will stimulate indeed a shift in seeing these people as workers, as employees, and treating them and protecting them as such.